So you've been discussing the terms of an agreement with someone else for some time now. You've had email discussions, phone calls, maybe you've met in person. You've also got some papers in writing now between you that sort of summarises some of the things you've agreed. You think the agreement's agreed, you've actually begun the arrangement, you've started the project, but something happens and you're conflicted over what one party thinks and what the other party thinks is a term to the agreement. You look over all these different bits of correspondence and you're not actually sure what forms the agreement and what doesn't. English law is, unfortunately or fortunately, very, very flexible in that it allows contracts to be verbal or written. So everything from your emails to your discussions in person can constitute a contract. When it comes to conflicts, that's obviously a problem. This could have been solved if you had a written agreement at the end of your discussions, and if that agreement contained what's called an entire agreement clause. An entire agreement clause should say and should summarise what constitutes the contract. Most of the time, a good entire agreement clause will actually say just this piece of paper constitutes the contract and none of the prior discussions, none of the prior emails. That's the best type of entire agreement clause, reason being that it summarises that the contract is just this piece of paper. It's really helpful for your lawyers because we only need to look at one piece of paper, and it's also really helpful for you from a record keeping perspective and for clarity.